You have a receipt for, did you buy this?
No, I'm sorry.
Don't leave, come back here. Don't leave, come back. Ma'am, come here.
I mean, I'm just trying to get stuff for my family. I'm sorry, and I don't want to go to jail. That's the last thing I need right now.
Why are you trying to run from me when I tell you not to move? Why'd I have to grab you? What's up?
She was waiting for her ride. Her Getaway car was actually parked in the front parking spot in that Handicap place.
You got it on camera?
Yeah.
On May 2nd, 2023, in Hillsborough County, Florida, officers responded to a reported shoplifting at a supermarket. The interaction lasted only minutes, yet it produced a felony arrest, a resisting charge, and an active probation violation.
You have a receipt for, did you buy this?
No, I'm sorry.
Don't leave, come back here. Don't leave, come back. Ma'am, come here. Ma'am, come here, stop. Don't run. What are you doing? What are you doing?
Please let me go.
No, you can't leave. You just got caught stealing. Come back here, you're detained right now. You cannot leave. Stay right here. Go to the sidewalk. Copy a signal 30 at Winn-Dixie. Ma'am, don't leave. Where are you going?
You're not. Stop touching me.
You're detained right now.
Stop touching me.
You are detained right now. You have to stay right here. You're not allowed to leave.
Okay, let me go.
Stay right here. You know,
So you code for?
Code for. Can I get a routine 94? Stay right here. Where are you going? Stand right here.
10-4, is there anything we fixed one?
Ma'am, you need to stay right here. What? You have an ID on you?
611, 51.
Stay right here. Do not leave.
10-4.
Ma'am, what are you doing? What are you doing right now? You need to stay right here. Hey, can you grab her arm? Ma'am, relax. What is wrong with you right now?
I need to go.
You can't leave. You are not leaving right now. Put your arms behind your back. Put your arms behind your back.
I'm not gonna try to leave.
No, it's too late. I'm not playing this game anymore. Put your arm behind your back, man. One detained.
Number 1 detained at 1856.
Can I stand up, please?
You gotta hold on 1 second. Come on, stand up.
Right on time, huh?
Pretty much. Where's your ID?
I don't have
You don't have one? You don't have one in your purse? Have another unit come by. Can you have the manager come up?
Yeah, I got you. You want me to take this in or leave it right here?
You can leave right here till he comes out and decides what he wants to do. Can you tell me what happened? Or would you need stuff?
Yeah, absolutely. I mean, I'm just trying to get stuff for my family. I'm sorry, and I don't want to go to jail. That's the last thing I need right now.
Why are you trying to run from me when I tell you not to move? Why'd I have to grab you? Do you think I want to do this?
No, I don't. I'm
I know they're you're scared, but you cannot run from the law enforcement when they're stopping you. You escalated this. I didn't have to put cuffs on you. I just have her detained right now.
Just looking for her on camera, actually.
So you want to get the prices of everything that she's taking, or?
Let's do it right now.
Do you have anything in your purse that you took also?
No, I mean, I don't know.
The lawfulness of the initial stop rests on Terry versus Ohio, decided in 1968. That decision permits a brief seizure whenever an officer has reasonable, articulable suspicion of criminal activity. Two independent facts supplied that suspicion here: the merchant's dispatched theft report and the absence of a receipt. The subject's attempted departure adds a third factor under Illinois v. Wardlow, decided in 2000. Wardlow holds that unprovoked evasion in a relevant context is itself a legitimate input to the reasonable suspicion calculus. American law draws a sharp line between a detention and an arrest, and that line controls what happens next. A detention requires reasonable suspicion. An arrest requires probable cause. The two are not interchangeable. Once a lawful detention is communicated, walking away is not a legal option. It is an independent criminal offense. That offense is codified at Florida Statute Section 843.02, resisting an officer without violence. The statute reaches any obstruction of a lawful duty, and physically pulling free clearly qualifies. Florida courts, including the 3rd District Court of Appeal in State v. Dennis, have applied that rule for decades. Use of force is analyzed under Graham v. Connor, decided in 1989. Graham requires objective reasonableness measured from the officer's perspective at the moment of decision, not with hindsight. Hand control and handcuffing, applied only after repeated escape attempts, sit at the low end of the force continuum. No Miranda warning is required at that stage. Miranda v. Arizona attaches to custodial interrogation, not on-scene questioning. The decisive legal factor here is the subject's active probation for a controlled substance offense. Under Florida Statute Section 948.06, any new arrest can trigger a violation warrant. Probation violations frequently carry no bond, and the original suspended sentence can be reinstated in full. That is the mechanism that converts a routine petit theft into serious prison exposure. Florida Statute Section 812.014 grades petit theft as a felony on the third qualifying offense. A staged vehicle in the handicapped space, captured on store camera, raises additional exposure. Florida Statute Section 812.015 governs organized retail theft and merchant detention authority.
Is there any way I could just be trespassed or something?
We'll find out when the other officer gets here.
Can we go inside?
Go for it. We're just gonna wait out here for a moment. Yeah, you know, let's go inside. Where do you want to hold her at? You want to take her inside the manager's office?
Yeah, we can. The boy,
What's up?
he was waiting for her ride. Her getaway car was actually parked in the front parking spot in that handicap place.
You got it on camera?
Yeah.
You got a tag on there or whatever? Even if you don't have one.
I'm gonna try to get a tag for you now.
1439 from last night.
I do got I think I got a plate for you.
All right.
All right, you're good to go.
Just make sure I'm back here.
We're gonna have to put that with your property. So with your bags and stuff. Yeah, I know.
All right, go ahead. There you go.
Thanks a lot.
Yep. You need anything else? You know what to put in your CRA and everything?
I'll figure it out. I'm gonna go to the station and get with Sergeant because of the probation.
Okay.
So he's gonna explain it to me. But shoplifting thing's pretty. She tried to flee, so I'm gonna have to add that charge.
Yeah.
I leave to grab
she
her,
tried to flee you.
and she was resisting.
Well, at least you know you wouldn't.
The primary officer earns a B+. The stop was constitutionally sound, and force stayed proportionate throughout. The subject earns a D. Every available legal choice was rejected, and the resulting cascade was entirely self-inflicted. Loss prevention earns an A- for documenting the theft, preserving plate footage, and deferring physical detention to sworn officers. 3 lessons emerge from this record. First, a lawful detention is not a negotiation. Walking away or pulling free only manufactures a new independent charge under Section 843.02. Second, the Fifth Amendment right to remain silent is the strongest tool available at any stop. Statements offered as sympathy or explanation carry no legal weight and are frequently used at the charging stage. Third, active probation multiplies every consequence. A single new arrest can reinstate the full underlying sentence. Let us know in the comments if there is an interaction or legal topic you would like us to discuss. Thank you for watching, and don't forget to subscribe for more analysis of police court interactions.